As the Supreme Court returns from Diwali holidays, a constitution bench led by CJI Lalit is expected to deliver its decision in the challenge to reservations for economically weaker sections of citizens. These reservations were introduced in January 2019 when Parliament enacted the 103rd Constitutional Amendment. EWS reservations are unique. The amendment allows states to provide reservations that solely consider economic criteria. It explicitly excludes backward classes who are already benefiting from reservation schemes. The amendment was challenged by a host of petitioners who claimed that reservations for economically weaker sections, or EWS reservations, discriminated against scheduled castes, scheduled tribes, and other backward classes. When the Constitution was framed, reservations were seen as a measure to address social, political, and economic inequalities faced by historically oppressed communities. So, petitioners in this case argued that reservations aimed at alleviating poverty derail the original purpose of reservations. In addition, they claimed that EWS reservations violated the SC's judgment in the Indira Sawhney case. In 1992, this 9-judge bench placed a 50% ceiling on reservations in educational institutions and public employment and said that this could only be breached in extraordinary circumstances. Since the amendment allows states to provide up to 10% EWS reservations on top of existing reservations, it would reach the 50% ceiling. On the other side of the argument, the Union government, through Solicitor General Tushar Mehta, repeatedly brought up one key issue. The reservations were introduced through a constitutional amendment, so the standard for striking it down is much higher than the standard for striking down other legislations or provisions. In the Bhim Singh Ji case in 1985, the court held that a constitutional amendment could only be struck down if there was a shocking and unconscionable violation of the right to equality. According to them, none of the petitioners' arguments showed that economic reservations were shocking or unconscionable. The former Attorney General K.K. Venugopal appeared for the Union as well, in perhaps his last high-profile case before his retirement at the age of 91. He argued that the existing reservation schemes for backward classes would remain unaffected after EWS reservations were granted. There is no ground for backward classes to claim discrimination. Further, he claimed that these reservations shouldn't even be considered within the 50% ceiling. EWS reservations form a separate compartment to address the overwhelming poverty within the unreserved 50% in the general category. According to Mr. Venugopal, even if the bench found that EWS reservations did not form a separate compartment, the overwhelming poverty creates an extraordinary situation to justify the 50% breach. He presented the 2010 Sinho Commission report, which analyzed who would qualify as economically weaker to substantiate his argument. However, he faced significant pushback from the petitioners. They claimed that the report showed that a majority of individuals falling in the EWS category would belong to backward classes, and the report itself states that there is a lack of data to justify EWS reservations. In the last Constitution bench heard by CJI Lalit, the judgment is expected to clarify certain fundamental questions about reservations. What is the purpose of reservations? What information should be considered when identifying who should benefit from reservations and to what extent? When can the 50% ceiling on reservations be breached? SCO made an arguments matrix explaining all the key arguments made in the case by various parties. Our prejudgment matrix discusses the possible outcomes in this judgment and how it will impact reservation policies. You can access them on scobserver.in. For updates on the Supreme Court, subscribe to SCO on all the usual platforms.